I'm Leandra Lederman.
I'm Allison Christians.
And it's time to break into tax.
Leandra, I have wondered, how does a civil tax controversy arise in the United States?
Oftentimes, a tax controversy starts with what the IRS calls an exam or examination and what we colloquially refer to as an audit.
So when you say audit, do you mean like IRS is sending agents to my house and looking at books and papers, or are they like typing things into a computer? What does this mean, audit?
Great question. There's multiple kinds of audits. A common audit used, especially today where the IRS doesn't have the funding that it used to, is what's called a correspondence audit, where the IRS just simply sends a letter and will ask for some information or documentation of some things on the taxpayer's return. The IRS could also do an office audit where it calls the taxpayer into the IRS office, or a field audit, meaning IRS agents go out in the field, meaning they go to the taxpayer, and typically that would be to the taxpayer's place of business. The IRS may audit the taxpayer and determine that there's some kind of understatement, and the IRS may send the taxpayer a document that's known as a 30-day letter or proposed notice of deficiency. It's not required by law, but oftentimes the IRS will do this. They'll send a revenue agent's report along with a 30-day letter to the taxpayer. And it's known as the 30-day letter because the taxpayer has 30 days in which to respond. In response to the 30-day letter, the taxpayer can request a conference with the IRS Appeals Office and file a written document called a tax protest if the document is required. And the IRS Appeals Office is very successful at settling cases. They're entitled to consider the hazards of litigation. So if the IRS feels, for example, it only has a 40% chance of winning on a particular issue, it could offer the taxpayer, we'll settle this for 40 cents on the dollar, for example.
So this 30-day letter sounds a little scary. Maybe, I don't know too much about the tax system and I'm a little worried, and maybe my fear makes me not want to answer it. So I just, put it in a drawer and maybe kind of forget about it. Then what happens?
Then typically what the IRS will do is they'll send what's known as a 90-day letter or statutory notice, notice of deficiency, stat notice. These are all terms for the same thing.
Okay, so now I get 3 months to really start worrying about what's happening to me.
Right. And the 90-day letter is required by statute in order for the IRS to use its administrative assessment procedures. So in order for the IRS to have the eventual right to seize property if the taxpayer doesn't pay, it has to actually assess the tax within the statute of limitations period, which is generally 3 years. There's some exceptions. And as a prerequisite statutorily for the IRS to use the administrative assessment procedures, it has to send this notice of deficiency, which gives the taxpayer the right to petition the U.S. tax court within 90 days. That's why it's called a 90-day letter.
So like a petition where I go around with like a clipboard and get all my friends to sign some kind of statement that I'm a good person?
No, not that kind of petition. In this context, a petition is essentially a complaint like you would file in another court. And the U.S. tax court has a form on its website that you can use as a basic petition. The notice of deficiency will alert the taxpayer to the options of simply conceding, waiving restrictions on assessment and paying or making arrangements to pay, or filing a petition in the U.S. tax court. And the deadline to file in the tax court is required by statute to be on the letter. And the tax court will send the case over to IRS Appeals if Appeals hasn't already considered it, to give the IRS Appeals Office a chance to try to settle the case. So the Appeals Office hears two types of cases: so-called docketed cases, which means they're already docketed in tax court, and non-docketed cases, which are ones that it receives in response to the 30-day letter.
So I understand there's tax court. That sounds like a straightforward way to complain, but I thought that there were other courts too, and you could go to those. How do those courts work together?
That's right. So what's distinct about the U.S. tax court is that the taxpayer does not have to pay the amount in dispute first. It's a deficiency action. But there are two other principal fora that hear U.S. federal civil tax cases at the trial level. And those are the U.S. District Courts and the U.S. Court of Federal Claims. And both of those are only available if the taxpayer is in a refund posture. So that means the taxpayer has to actually pay the tax in dispute and then file a refund claim and then either wait for the IRS to disallow it or waive disallowance. And then the taxpayer could file a complaint either in the applicable U.S. District Court or in the U.S. Court of Federal Claims. And the taxpayer has to full pay. So if you're in the notice of deficiency context, in order to go to one of the refund courts, you have to pay the full amount in dispute. You can't simply pay part of it and then count on the IRS to counterclaim the rest. There's a U.S. Supreme Court case called Flora, which says that. And the only exceptions are for taxes that are so-called divisible taxes, generally employment and excise taxes. And those are taxes the U.S. tax court generally does not have jurisdiction over.
So if I go in the tax court and I get a decision I don't like, where am I appealing to? And is that different than the district court and the Court of Federal Claims?
Appeal from the U.S. Court of Federal Claims lies to the Court of Appeals for the Federal Circuit. For the U.S. District Courts and the U.S. Tax Court, appeals lie to the other circuit courts of appeal, which are geography based. And then from any of them, the U.S. Supreme Court can hear the case on certiorari, which is not an appeal as of right. Appeal to the courts of appeals is as of right, but the U.S. Supreme Court controls its docket, and it only grants a limited number of cert petitions every year. The U.S. Supreme Court does hear maybe one or two tax cases each year.
So all the roads lead to the Supreme Court, but a lot of times the Supreme Court puts up the stop sign and says, we don't want to hear your case. And in that case, you are stopped at that second level, that appeal level. And that's how you can get different rulings in different cases across the United States.
Right. I've mentioned going to refund court in response to a notice of deficiency. You can also get there another way, which is taxpayers file refund claims all the time. They may file a refund claim because they've already filed a return and they have some reason that they want to amend it and claim a refund. They realize that they omitted a deduction or something like that. But also a lot of taxpayers simply file a refund claim as their first return of the year. That would be in a situation where the taxpayer paid too much during the year. They were over withheld or they paid too much in estimated taxes or something like that. And the tax system is set up to actually put most individuals in a refund posture. So people are getting their tax refund at tax time. Well, what if the IRS does not issue the refund or doesn't issue all the refund because it reviews the return and it determines that the taxpayer isn't entitled to all of it? The taxpayer's path to getting it back is exactly the same as if the taxpayer had paid the amount in response to the notice of deficiency and pursued the refund path.
If I'm going to go that route, how do I decide which of those I'm going to go to?
It's a forum shopper's dream. There's three different courts. The U.S. tax court only has jurisdiction over tax cases. The district courts have jurisdiction over federal cases generally. So those judges are not tax specialists. And the Court of Federal Claims has jurisdiction over suits against the government. So they hear some tax cases, and they also hear patent cases and a number of other cases involving suits against the government. The U.S. bankruptcy courts also do hear tax matters that arise in bankruptcy. So that is a fourth court that can hear U.S. civil federal tax cases at the trial level. I don't mention that because it's not one of the options that is triggered by getting a notice of deficiency. Factors that a lawyer would often consider in deciding which one to go to is, first of all, does the taxpayer have the ability to pay the amount in dispute up front? That's important. If yes, then we should consider the fact that the tax court judges are tax experts. So if it's a very technical tax matter where maybe the taxpayer has some esoteric legal arguments in the taxpayer's favor, that might counsel going to the tax court. On the other hand, if it's something where maybe that's not the case, Maybe the facts are really sympathetic. Well, the only one of the three where a jury is available is in the U.S. District Court. That's the only one that's formed under Article 3 of the U.S. Constitution. Both the Court of Federal Claims and the Tax Court are Article 1 courts, and they do not have juries.
Okay, so as a taxpayer, I'm trying to decide, do I think my peers will be sympathetic to my cause? And if I do, then I might want the district court.
Right. Now, that's really rare. Keep in mind that of U.S. civil federal tax cases that are litigated, over 95% go to the U.S. tax court.
This makes sense because if I feel that I don't owe the money, I don't want to pay it and wait to get it back.
That's right. Interest runs, so that works out in the end, but a lot of people don't like to pay up front. Also, another reason that I think is important is the notice of deficiency that comes from the IRS tells you you have 90 days to petition the U.S. tax court. It does not mention that there is any other alternative. And over half of the taxpayers who file in tax court are pro se. 90 days is not a lot of time. And a lot of times what taxpayers do is maybe they talk to their accountant, but most people don't have a tax lawyer lined up. And so they may go ahead and file the petition pro se, and then possibly they look for a tax lawyer afterwards. And once you've petitioned the tax court, you cannot get out until the judge enters a decision in the case. Even if you settle, then it's entered as a stipulated decision. So you don't have the option to just voluntarily dismiss and then go to one of the refund courts. And there's no possibility of getting a transfer from the tax court to one of the other courts. So I think that there's some number of cases potentially that go to the tax court where the taxpayer just didn't know that there was any other alternative.
It looks like the path of least resistance.
Yeah, it's the path of least resistance. It's the only path that's flagged. There are some other differences across the courts. It's possible that different precedent would apply. If there's a U.S. Supreme Court case on point, that's controlling everywhere. But usually if there's a U.S. Supreme Court case that controls the outcome, that case is going to settle. So often what we're looking at is if there's any precedent, it might be in one of the courts of appeals, or possibly the U.S. tax court has decided this issue before. The precedent that applies tracks where appeal lies from each of the courts. So the Court of Federal Claims is distinct in that appeals lie to the Court of Appeals for the Federal Circuit, which only takes appeals from the Court of Federal Claims. So if there's precedent in the Court of Appeals for the Federal Circuit and it's favorable to the taxpayer, well, then the taxpayer, of course, would want to file in the Court of Federal Claims. Otherwise, if there is a Court of Appeals decision, then that precedent would be the same regardless of whether the taxpayer goes to the U.S. District Court or the U.S. Tax Court. So for example, I am a resident of Indiana. If I were the taxpayer in a case and I were to litigate in the U.S. District Court, appeal would lie to the 7th Circuit because Indiana is located within the 7th Circuit. And so that precedent would apply. The U.S. Tax Court decided in a case called Golson versus Commissioner that it will apply the precedent of the Court of Appeals to which appeal would lie if it's squarely on point. So if there was a 7th Circuit decision, it would apply to me equally whether I went to the U.S. District Court or the U.S. Tax Court. But if there's no decision squarely in point, even if there's a decision, let's say in the 5th Circuit or the 1st Circuit, then the U.S. Tax Court can apply its own rule.
We've now traveled down the path of assessment and appeals and complaints and petitions in the U.S. context. And I think it's important to note that the U.S. has its own specific courts and its own specific processes, but you'll see some common elements in other places. And there's always this interesting questions about which court has jurisdiction to hear what kind of cases and what the different avenues are for taxpayers.
Tax controversy work is really interesting. It's its own specialty. Like other areas, there's a lot of theory to it, as well as a lot of technical details. You could take a whole course on tax procedure. So this has just been a little bit, but we hope that it will help you as you break into tax.
See you next time.